Today I'm going to talk about getting bank statements in a probate setting. I'm going to assume that you have been appointed as executor or administrator of someone's estate. The person who died, we're going to call that person the decedent. And we're going to call you the executor because it's easier. Just most people are executors. But if somebody doesn't have a will, they're an administrator. But beyond that, there's really no difference in the job. So as soon as you've been appointed, you receive an order from the court and a document called letters. The letters are like your passport or like your driver's license as the executor. You need to take those letters and a death certificate for the decedent down to every bank where the decedent had accounts. Okay, every bank, every brokerage, you need to take that the copy of the letters, and it has to be the original letters with the purple stamp that is on it, making it official from the court. They're called certified letters. And you need to take the official copy of the death certificate. When you get to the bank, you tell them that you want to take control of all of the decedent's accounts that are at this bank. Because it could be, you go to Wells Fargo thinking there's just one account, and there could be four, and you want to take control of all of them. It's possible that the person at the bank is going to tell you, well, we can't give you control of all of them because one of them's in a trust. And if you're the executor, you're not the trustee, you can't take control of a trust's account. You can take control of the decedent's personal account, but not a trust account. Or the decedent might have had an account held jointly with somebody else, and now that account belongs to that other person. Well, the bank is not going to give you access to that account either. The probate accounts, the ones in the decedent's name alone, the bank will give you access to. But you're going to have to fill out a few forms and everything. So while you're there busy filling out the forms, make sure to keep in mind that you need to ask for the date of death statement. So let's assume that the decedent died on December 8th, 2020. That means that you need to get a bank statement for each of the accounts held by that bank, starting on the statement that includes December 8th. So you're going to have to give these statements to your attorney or to your paralegal, and if you come there with a statement that starts on December 9th, it's not good enough. It needs to include December 8th. And I would actually recommend that you get the statement from the month before the date of death, but that's not required. Sometimes there's information in there that can be very helpful though. So I would recommend that you ask for that, but you need the date of death statement and you need every subsequent statement up to the present. And the banker may say, well, how about if we give you a printout? No, you can have a printout of the bank statements, the ones that would have been sent in the mail, but you can't just have a computer printout of the transactions. It has to be the official statement document with Wells Fargo or Bank of America's name on it. And it has to be every page. And you know, sometimes the statements say, page 6 of 6, and it's a bunch of legal gobbledygook, and it's too small for you to read anyway. Actually, you need to include that. Don't take any pages out. We need every page. And we need every statement from the date of death until you close the account. Now, in most estates, not every estate, but in most estates, all the accounts are taken over by the executor, and the executor takes all of the assets from those accounts and closes those accounts and takes all the assets out and puts them in a new estate account that's in the executor's name as executor and then has the new tax ID number for the estate. So you're closing the decedent's account. And if you're closing the decedent's account, there should be a closing statement saying that the account is closed and the balance is zero. That's also what you need. So you need the statements all the way until you've zeroed out each of the accounts. I understand that there are some decedents who for various reasons have accounts in 20 different banks. If that's the situation, ask your attorney, ask your paralegal to help you out. You can sign a form giving the law firm the right to ask these questions, and a lot of times the banks will send us the statements, and it can save you a lot of work. All right, I hope I've cleared up what you need to do with respect to the decedent's accounts as soon as you've been appointed executor. This has been Trust and Probate Attorney Ed Goodson. Thank you very much.